Welcome to PeakCare in Focus. My name is Lindsay Wegener. I'm the Executive Director of PeakCare, a Queensland child protection peak body. A few weeks ago, PeakCare released a video that we called A Human Rights Act for Queensland, Needed or Not? That's the question that's currently being examined by Parliament's Legal Affairs and Community Safety Committee. And we were joined by one of the driving forces behind a campaign for a Human Rights Act for Queensland, Ms. Amy McPhee. At the end of the video, we invited you to send in your comments and questions, and Amy kindly agreed to return to respond to some of those. So, welcome Amy.
Thanks, Lindsay.
Amy's not returned on her lonesome, however, and she has been joined by some other invited guests, and I've a great deal of pleasure in introducing them to you at the moment. James Farrell, who's the Director of Queensland Association of Independent Legal Services, Janet White, Director of the Youth Advocacy Centre, and next to Amy, Karen Walsh, who's the Chief Executive Officer of Micah Projects. Amy, I'll kick the discussion off by turning to you. And a question that we received was about a person who went to great lengths to say they were supportive of human rights principles and standards being built into legislation. What they talked about was, isn't it better to ensure that legislation that's relevant to a particular area of human services delivery, whether that be child protection or disability services, isn't it better to ensure that that legislation has those principles and standards built into that legislation? So, for example, the Child Protection Act. Isn't it better to incorporate those principles and standards within that legislation rather than go to a separate piece of legislation such as a Human Rights Act?
Yeah, thanks, Lindsay. And it's a good question, and one that actually does come up a lot in my discussions with people. And I guess the way that I would answer it is this, is that a Human Rights Act is really a decision-making framework. And so by introducing a Human Rights Act, what we're actually then enabling is that regardless of whether you're a child safety officer or a prison worker or someone in the Department of Housing or someone working in a disability service provider, that we can all expect that their decisions are going to be made in a way that's consistent with agreed upon human rights values associated with freedom, respect, equality and dignity.
Right. Karen, a similar question was asked by another viewer. And they recognise that the Child Protection Act is currently subject to a review. What they noted was that the Child Protection Act already incorporates a Charter of Rights for Children in Care. Their query was, well, shouldn't we also include a Charter of Rights for parents, for example, that is informed by human rights principles and standards and that governs the kind of behaviour that should be dealt with, how we should be managing ourselves, the child protection system, in our interaction with parents. Isn't it better to make sure that that's within the Child Protection Act rather than go to a Human Rights Act?
First of all, I don't think everyone in our society is governed by the Child Protection Act. So I think the Child Protection Act certainly could have better principles about administrative fairness and working with parents, and that parents understand the decision-making process has been fair the whole way through the child protection process. But I don't think that's what a Human Rights Act is. I think a Human Rights Act is really important for our society and community as a whole. It's important that it's grounded in our parliament and that politicians are held, it's reported back to politicians how that the elected representatives of a community, it's an important part of how we as a community live in a democracy and meet our obligations that we as a community have said we want for all of us, but particularly for people who are vulnerable or with specific needs or diverse groups of people that may have some different needs to mainstream. So I think it's really important that it's not just about services, it's about the way we want to live and the access and distribution of resources. And people need to be able to, when they feel discriminated for not getting a service, you know, that's a human rights issue, and sometimes when we have acts that are just around services, you're only looking at it in terms of what is happened if you got the service, whereas we have a lot of people who across the community have not been able to access the services that they're entitled to because we don't meet our obligations or understand how our resources are excluding people. And I think a Human Rights Act is a way for decision making and scrutiny of our policies that governments have across all departments, whether that's accessing justice or accessing housing or child protection. But we need to make sure that there is scrutiny about those policies and the impact that those policies have on people's lives. And in relation to child protection, for example, we are removing children because people can't access affordable housing, and that families can't live together because they don't have the resources. And I think that the cross-government issues that impact on the ability of us as a society to value and enact human rights is a really important difference to legislation that is about particular service delivery.
Thanks, Karen. Some of your comments reminded me of a video that was recently produced by the Queensland Anti-Discrimination Commission, and that video was done in partnership with the Human Rights Act for Queensland campaign, and it featured interviews by Helen Zoka, the Chief Executive of Oxfam, and also Mick Gooder, the Australian Human Rights Commission's Aboriginal and Torres Strait Islander Social Justice Commissioner. And I'd certainly recommend that people who watch this video also watch that one. There's something that Mr. Gooder said on the video that matched very strongly with some of the statements you've just made that I was hoping that James might comment about. And I'll just read to you what Mr. Gooder said, which was, in the federal government, we've now got a Human Rights Scrutiny Committee that looks at every piece of legislation that goes through Parliament, that's federal Parliament, to see if it complies with our human rights standards. I think that something of that sort would be pretty useful in Queensland, particularly when we're proposing different laws. It's almost a quality assurance tool. So Mr. Gooder went on to describe the role of that committee as providing a check on whether the federal government is doing the right thing according to human rights standards. For example, were the people who were going to be affected by a particular government policy consulted and involved in the decision making. So, James, what's your view about Mr. Gooder's statement, and do you think there would be value in having a committee such as that one attached to Queensland, so that Queensland legislation, when it's before the House, could be reviewed by that committee?
Lindsay, I think when you look at comparable human rights laws around Australia, in other parts of the world, they have particular mechanisms or processes by which human rights can be better protected. They exist at the place where laws and policies and programs are developed, like in parliaments or in other parts of government. They look at where those things are implemented through service delivery or the decisions and actions of people within government, and they have some kind of accountability mechanism at the end, and often that's in courts and tribunals, but also through ombudsmen and commissioners and things like that. And so when we talk about the type of Human Rights Act that we want for Queensland, or the ways in which human rights can better be protected, it's more to look at all of those mechanisms and where they might fit in. So I think Mick's very right to say that looking at the process by which new laws are made is a good opportunity for us to think about ways in which human rights can better be protected and promoted. The Commonwealth Government looked at introducing a Human Rights Act about 8 or 9 years ago, and while the independent inquiry recommended that they do that, they kind of scooped it and came up with a bit of a compromise model, which includes a new scrutiny committee that looks at whether new laws comply with the international human rights instruments to which Australia is a signatory. It does a pretty good role at that. The parliamentary committees that look at these things in Victoria and the ACT do a pretty good role of that as well against the human rights that are mentioned in their laws. So I think it's really important, if we are looking at ways to better protect and promote human rights in Queensland, one of the mechanisms or processes that we should be talking about seriously is in parliamentary processes, in the making of new laws, how that might happen. It might happen in a committee, as Mick suggested. I think that's entirely appropriate. might be ways to look at ways in which the explanatory memorandum or the statements that people bring into Parliament consider human rights, the ways in which fundamental legislative principles that are already considered in lawmaking are used. They're the types of things that we should be using to front load laws and policies and programs to ensure that they recognise human rights and that they strengthen human rights protections.
And hopefully would bring about some of the effects that Karen was talking about in enmeshing that thinking and behaviour into government. Okay, when we're talking about the roles of different forums and so on, in your earlier interview, Amy, you talked about a particular role that could be attached to QCAT. There was an argument created around the accessibility of QCAT compared to some of the higher courts. For people who may not be aware, QCAT stands for Queensland Civil and Administrative Tribunal, so it's a tribunal rather than a higher court. A concern has been expressed to us that, given the importance of human rights, that it should be a higher court that makes that judgment rather than QCAT. So it's, I'd be interested in how you think that those sides of the argument should be balanced, one of accessibility versus the importance of human rights, therefore it's a role to be administered by the higher court rather than QCAT.
Yeah, thanks, Lindsay. I guess I'd approach that by saying that we're really fortunate in Queensland because we have other experiences to draw upon, and in particular we have the ACT, Human Rights Act, and the Victorian Charter of Human Rights and Responsibilities. And those pieces of legislation have existed since 2004 and 2006, and both have been reviewed on a number of occasions. They're slightly different, the models, and so in the ACT you can make an application to the Supreme Court when you allege that your human rights have been limited. In Victoria, currently it's a little more complex. You have to make an argument based on the Charter. You have to make that argument within existing proceedings. So, say for example, you've got child protection proceedings on foot, you're able to raise the Charter in those proceedings, but you wouldn't be able to bring an action based just on an infringement of a right contained in the Charter. So that's sort of become a little problematic for people seeking to access justice using human rights legislation. And recently, in fact last year in September, the 8-year review of the Victorian Charter was released, and that was an independent review. And in the report, it said that it was really important that the legislation be accessible, that it be effective, and that it be practical. And so that's where the recommendations were, they're the things that the recommendations were linked to. And Michael Brett Young, the writer of that report, did consider dispute resolution and said, and made a lot of comments about the fact that people weren't able to access justice easily through the current mechanism. And so what he said was that in order for people to be able to access justice, they needed to be able to access an alternative dispute resolution process, which he recommended sit with the Victorian Human Rights and Equal Opportunity Commission, and that if that dispute resolution process didn't solve the problem, then the person could make an application to VCAT, so their equivalent of our QCAT. And that recommendation is really based on the fact that many people that experience human rights issues don't have the financial resources to make an application to the Supreme Court. And the experience in the ACT and Victoria that making people make an application to the Supreme Court is a significant barrier for people accessing justice. So if we make QCAT, I think it's important that we look at our existing systems, that we see what can be achieved using the resources that we currently have. And we know that QCAT currently has a human rights jurisdiction. And so it makes sense in terms of simplicity and accessibility and affordability that people are able to access that tribunal with their complaints.
Jenna, I imagine that the issue of accessibility is something that's close to your heart, the accessibility that young people have to these kind of processes, and whether you have some comments and thoughts about that, balancing the argument between accessibility versus the importance of Human Rights Act that might be reflected in a higher court managing it.
Thanks, Lindsay. My thought would be that young people really wouldn't be bothered whether it was QCAT or the Supreme Court. They would just like to be heard. And that is a major problem for young people. Even those processes in QCAT, which are theoretically at least more accessible to the general population, much perhaps less formal, they are still a problem for young people. And that's shown by the very small numbers of young people who actually go to QCAT, even though there are opportunities for them to make complaints to that body. The problem for us is that young people, children, are generally not considered at any stage in terms of listening to them, in terms of hearing them, in terms of hearing what they've got to say about policies in general, about their human rights in general. And the hurdle of making a complaint is one step further. And I think the important thing would be that a Human Rights Act actually was quite clear about the rights and protections of children, so that, as we've discussed during this afternoon, that culture of understanding and respecting human rights becomes something that we all do on a daily basis. So whilst I understand that the point of a Human Rights Act would be that essentially government actions would be held to account, you would like to think that that would model a behaviour which would then be taken up throughout the community, and particularly by some of the leaders within our communities in a range of ways. And that by doing that, young people won't need to complain about abuse of their legal rights, because somebody will be listening to them, somebody will be advocating for them, somebody will be taking that up. But we certainly need to look at how we make the systems, which are still essentially adult-focused, child-friendly, young person-friendly. That doesn't mean simplistic, it doesn't mean patronising, it means actually putting in place a process that allows that young person to participate in a way which is comfortable for them. That often makes adults very uncomfortable, and that's the problem. The adults tend to win out in those arguments. So yes, I think if we're going to make a Human Rights Act work, there has to be some way that people can, some way that people can find support, a way to draw attention to the fact that their rights have been violated. But we're going to have to make sure that everybody can access a mechanism to do that, and those mechanisms might look a little different depending on the people that need to access them at a given time.
Yeah, they're interesting observations. So it's not only about what the structures are or the venues where decisions are made, it's about all the behaviours and the culture, really, that it needs to inform how that's managed. Yep. Okay, I want to go back to Mick Gooder again and quote him again, because he's such an impressive spokesperson for human rights, of course. It's during the earlier interview that we had, Amy, we also did certainly make mention of the special significance of a Human Rights Act to Aboriginal and Torres Strait Islander peoples. And that's out of consideration of the past atrocious violations of their human rights, whether that we're looking at the impact of the era of stolen generations or stolen wages or back to colonisation itself, and the legacy of that we still see in the incredible disproportionate representation of Aboriginal and Torres Strait Islander children in the child protection system. I'd like to again look at something that Mick Gooder said, and I'd like to also say that it's not appropriate for PeakCare to comment on the hopes and aspirations that are held by Aboriginal and Torres Strait Islander peoples themselves about their human rights and how a Human Rights Act might benefit them. That's for them to say. But there is an interesting statement that Mick Gooder made that I'd like to hear your opinion about. And what he said was that A lot of us argue that the best interest of a child is keeping a family together. So it could be that you actually use a Human Rights Act to ground that, to say that we've actually got to take a focus on supporting families. I'm interested in your opinion about that, Janet, because I think that certainly while there's a special significance of that to Aboriginal and Torres Strait Islander children and families, it's something that also applies to all children, I would imagine.
I think that's absolutely true. I think all of us, I think perhaps Karen in particular, would have experienced that situation where a young person is in care for a lot of their life, but once they leave care, eventually they make their way back to their family. Their family and their parents, no matter how dysfunctional that relationship might have been or the difficulties they might have had, it's still essentially their family. And the Convention on the Rights of the Child is very clear. It even says right up front in the preamble, it is the family that has the major responsibility for bringing up a child, the child they have brought into the world. And so a Human Rights Act would, I think, help to support the fact that families need support. Families who are struggling, families who have got difficulties for a whole range of reasons, should be provided with the necessary supports and services so that children can grow up within their families, within that environment which is clearly fundamental to us as human beings. And I think this would be a good mechanism to keep referring back to. And I would like to see probably that the Act made some reference to the Convention in terms of that level of support. The whole issue of early intervention and prevention, which we say is so important in the child protection and youth justice spaces, is really all about keeping family together, helping parents who, in a non-judgmental way, that's the really important part, so that people don't feel judged, don't feel that they failed, but we help to provide the best support to young people and the best start to life.
Karen, would you like to comment further about that? And how would, in your opinion, a Human Rights Act assist in better understanding why we should be placing a focus on keeping families together, but also that understanding about what is in a child's best interest? We sometimes throw around the term and bandy around the term best interests, but rarely do we really define it very well.
I think that a Human Rights Act would change the discourse to a good parent or a bad parent, and that we would look at the personal circumstances of a family, but we would also look at the structural inequality about why children are in the position they're in and why parents are in the position to not be able to enact what they believe their hopes and dreams for their children are, because that's often the issue, that people don't have the ability to find the resources. We talk about the really terrible situations of where, you know, there are families in which murder, injury, sexual abuse and these things occur, but that's not the majority of people that we're dealing with in a child protection system. Most people in the child protection system are there because of poverty and neglect and structural issues that are outside their control sometimes, in terms of accessibility to services, eligibility criteria to get into services, waiting lists. You know, there's certainly a gender bias about the role of the mother in terms of responsibility, her responsibility to protect rather than to hold perpetrators accountable in incidences of domestic violence, for example. So I think that if we had a Human Rights Act, the way we would talk about the kind of realities that people have when they live in poverty and they live with the daily realities and consequences of trauma. And in Australia, we can't ignore that our systems have created this as an intergenerational issue for Indigenous people and Indigenous families, as well as for families who have lived in poverty or have intergenerationally been in care of the state. That it's a cycle that just keeps going, that we really do need to break. I also think the way we make decisions is important, that sometimes it's not about whether a child's in care in out-of-home care or in the family, either way they need to know their family respectfully. They need to know the circumstances that have led to why a decision's been made one way or another. Because the trauma that I've certainly witnessed over years of listening to people who are in care, Indigenous and non-Indigenous, is they thought they were there because they were abused and neglected, only to find they were there because of legislation, whether that was, because of the White Australia policy, or it was about moral danger, or it was about their mother or father had a mental illness, that someone was unemployed and didn't have the economic means. And it changes their image and identity of what they see their family history is. So I think a Human Rights Act should really, provide that framework for how we actually talk about each other's circumstances and how we explain the decisions that are made in a way that is respectful to not just someone's capacity and personal circumstances, but to the kind of resources that are available to them in a society that we're responsible for. We've created it. Governments have a huge role in creating accessibility to services like housing, as well as housing, employment and other things. So I think all those things need to be part of how we describe decisions that are made when children have to be removed, but also that they shouldn't be the reason they're removed.
Some of this discussion reminds me of the preliminary submission that PeakCare made to the recent Queensland Child Protection Commission inquiry, and within that submission we provided some potted history, I guess, of child protection, and within that described some of those things that Karen was mentioning. We talked about the dangers of a moral construct often being placed on child protection, and also cultural construct, and certainly we talked about the most evidence, the strongest evidence of that is the diabolical treatment of Aboriginal and Torres Strait Islander families, where through no other reason than race alone, Aboriginal children were under law defined as neglected and destitute, and therefore could be removed with no appeal rights about that. But there are other groups who have similarly suffered because of moral and cultural constructs being placed on how those groups are viewed. So many Australian governments have recently moved towards making, or have completed, an apology to families, to both parents and children who were subjected to forced adoption practices of the past. But we've also seen many families placed in a position because of prevailing social norms or economic hardship, or being forced into a position of really relinquishing the care of their children. And so we talked about, in this extract from our submission, some of the safeguards have been built into the system to protect against those kind of constructs being imposed upon families and children. But I think it's a question about, have we gone far enough? Have we eliminated those dangers? Certainly in our submission to the inquiry, we concluded the dangers are still there. They are still lurking there, and despite some of the safeguards that we have in place, what we concluded was that despite these safeguards, however, inherent within the struggle to reshape the child protection system is a failure to fully appreciate that the children and families the system is intended to service are not an homogenous group. The reasons for their contact with the child protection system vary widely, as do their responses to the range of interventions and services they may receive, along with the pathways made available to them in accessing their services. While some children and families may be viewed as having a profile that characterises them as being vulnerable or at risk, exceptions can always be found. Child abuse and neglect is not confined to any particular socioeconomic group, nor is it the inevitable consequence experienced by the children of single parents or parents who are abused or neglected themselves, or have an intellectual disability, or formerly spent time in care, or who are Aboriginal or Torres Strait Islander. While services that are targeted towards particular cohorts of children and families may benefit many, there are continuing dangers of value-laden constructs being applied in the name of protecting children that unfairly and unjustly draw attention to and discriminate against some groups, both in relation to who is reported, the pathways made available to them in accessing services, and the nature of response that they receive. So I'm interested in comments from each of you. How much do you think we have addressed some of those dangers? How far have we got left to go with that? And do you think the Human Rights Act will be of assistance in ensuring that those kind of moral and cultural constructs are not imposed on families unfairly? Amy.
I think what I'd like to say about that is that I see a Human Rights Act as a value-laden construct itself. And so, but rather than, it shifts our gaze from judging a family situation to, it moves our gaze to the decision maker. And so it actually applies a value-laden construct on the decision maker. And it says, are those decisions that you're making consistent with the universally accepted human rights that exist? So are your decisions consistent with values associated with freedom, with respect, with equality and with dignity? And I think that when we turn the gaze to the decision maker and scrutinise their decisions using those values, we're actually moving towards making sure that decisions are consistent with values that we all agree upon.
Karen, any other comments about that? That's an interesting way of Amy's reframed that whole argument, isn't it?
Yeah, well, I agree. I think that we've got to move beyond a culture of governments apologising to governments being accountable and preventing. We've had 20 years of apologies for both international with the child migrants and in Australia with Aboriginal and Torres Strait Islander and with anyone else in the community who have come from a range of backgrounds in terms of disadvantage and poverty and mental illness that have been apologised to, forced adoptions. And it just keeps happening, and I think that we have to absolutely shift the frame of reference about decision-making and values. We need to look at a decision-making framework for how we invest, where the money goes, while we're putting, while we've had inquiry after inquiry stating very clearly that the removal of children is harmful as well as beneficial. We focus only on the beneficial, but all of the situations in which it hasn't been beneficial that's the evidence for the next inquiry. And I think that we just absolutely have to start looking at being accountable for decisions that are value-based in human rights and dignity, and everyone's life isn't going to be equal in terms of resources, but it should be equal in terms of their worth and value to be given resources. And I think as long as we're putting, $1 billion or whatever the budget is into child protection and nothing into housing, we're just going to end up with all these inequities that just keep going round in cycles. So I think that's a really important shift that we've got to make, and we have to be mature about it, because to do it we're going to have to give up some things that we're doing and do other things very differently.
Before asking you to comment, Janet, there's something I'd like to read to you that came from a Director's annual report of the Queensland Department of Children's Services at the time, in 1967 this is. But, but the quote actually is, the problem, and it was talking about, it was an explanation about the high numbers of, in quotes, intractable girls that were being detained in training homes, and the conclusion was drawn that the problem involving girls is generally morals, but in a few cases they've been involved in offences. And that really started to build momentum towards one of those previous inquiries that Karen mentioned, which was the DEMAC inquiry in 1976. And that was at the time when sexual abuse was discovered, and that young women were started to be listened to when they started to discuss the fact that they'd been sexually assaulted, and some understanding about acting out behaviours that might be linked to sexual assaults. So I'm interested in that shift, I think, in culture maybe, or how far are we yet to go in ensuring that we get to a point that Amy's talking about, rather than have other kind of cultural values or moral values imposed upon families in ways that sometimes aren't at all helpful.
I think it's quite complicated, really, because it's all about judgment. It's all about the fact that we need to judge people and we need to find somebody responsible. And if this young girl is acting out, well, obviously she's responsible. She's the one that's acting out. She's the problem. And I guess if we're going to go back all those years, we can go back to the 1980s when I was going into what was then the Sir Leslie Wilson Youth Detention Centre, when young women were locked up for being uncontrollable. So they weren't charged with criminal offences. The boys were generally there for that, but the girls were there for being uncontrollable, and that was often around sexual promiscuity or running away from home and doing goodness knows what, basically, as far as the people in authority were concerned. And that was all about judgment about those young women, absolutely, because what always amazed me was nobody ever asked the question, why? Why are you doing this? What is going on in your life that this is how you feel that, you know, you have to survive, or this is how you get your sense of belonging or inclusion or whatever? And whilst some of those things have changed over time, I still think that level of judgment is still there. There is still a level of judgment about young people, which is about whether you're a deserving or an undeserving young person. We find it very difficult at the Youth Advocacy Centre to try and get people to understand that young people who are engaged in offending behaviour may well be the same young people who've experienced situations which mean that they are also in care. So we know 70% of young people who offend are known to child safety, but it's this whole thing, we have to judge the child, we have to put blame on the child, we don't take responsibility. And the thing about a Human Rights Act is, I think that's what it's doing. It's saying, where does the responsibility sit? And if you take on board some of the Convention on the Rights of the Child, and particularly say Article 18, which says state parties shall render appropriate assistance to parents and legal guardians in the performance of their child-rearing responsibilities, then you're back to saying, so what is it that we did as a government, as a community, that actually addressed what needed to be addressed for you as a young person to grow up in a safe and secure environment? But I think whilst the judgments may change a little bit, care and control has indeed gone, I think we run the risk that these things come round in a cycle and that judgments are still being made. And things like, as we've known, we've talked about the secure care issue, you know, which young people are they going to be? And I would guarantee they're going to be the most traumatised young people, the young people who've got the least support. And what are we doing in that space? We're going to lock them up again instead of actually going back and saying, so couldn't we have done something more proactive, more assistance to the family and to that young person?
James, how do you think Human Rights Act will shift us towards the thinking that Amy really talked about in her framework? How will it help, and does it help to guard against some of those dangers that we see within systems such as child protection?
Lindsay, I don't pretend to be an expert on child protection, but it seems to me that when you talk about those value-laden structures or frameworks, they fall down when they are absolute or strict, when they say the way to solve this problem is to take this particular action, remove Aboriginal and Torres Strait Islander people from community, and that will fix a perceived problem, or lock up immoral or uncontrollable young women, and that will fix the problem. And so I think when it's a strictly applied construct, that's when the system falls down. I think the real value of a human rights discussion and the types of models in Human Rights Act that we might be considering here in Queensland is it brings together a number of the factors that people need to consider when making those decisions. often those considerations are in tension, and so when you're balancing the rights of a child to cultural life or the primary rights of the family against right to freedom from cruel, inhuman, degrading treatment, which are the way that some of those rights are articulated in human rights law, it creates the space to have a sensible and measured conversation that takes into account the complexity that Janet spoke about of a child or young person, their family, their community and the state. And so providing a framework to have a sensible, balanced conversation about those competing and complex ideas, I think will result in better decision making and better outcomes.
I think one of the points that Amy made very well in our initial interview was that the relevance of the Human Rights Act to all of us. So at this moment in time, maybe the people sitting here at this table won't benefit terribly much by a Human Rights Act, but what happens if we suddenly experience a serious medical health concern, for example, where we will be requiring interventions by some kind of institution, how we're going to be treated in that process, or we could be wrongfully arrested for a crime we have not committed and be incarcerated, or we may have a child attending a daycare centre or a school, or a grandchild attending a daycare centre or a school. So all of us at some point are potentially going to be engaged with government or non-government organisations where our human rights could be a threat. I guess not to want to exaggerate that, but could be at some kind of threat in our dealings with those kind of institutions. So how do you think a Human Rights Act the relevance of a Human Rights Act to all of us?
I think there's an issue, Lindsay, when people think about human rights or talk about human rights, they're often tempted to think about the severe international human rights abuses and the experiences of people in parts of Africa or parts of Asia or other places in the world rather than here in Australia. And I reflect on my time working as a community lawyer in Victoria after the Charter was introduced and thinking about the types of people that came to seek our help and the way in which having better, stronger human rights protections was able to assist them. And it wasn't something that applied to those severe abuses, but it was things like making sure that before being evicted into homelessness by a social landlord, that people's rights were considered. It was about the type of medical treatment that they should get and their participation in the decision making around that stuff. For people who developed chronic disabilities or chronic injuries or diseases, they're the kinds of things that can affect us all, and they're the kinds of things that, certainly my experience in Victoria, suggested that a Human Rights Act or a Charter of Human Rights can deliver demonstrably better outcomes for people engaging with those kinds of problems, which can be any of us.
Mm. And certainly all the people watching this video at the moment, it's not only the children families with whom they're working, but it's themselves. It's the people who are watching it. I'll just let Amy talk a little bit about how the campaign is going and also what the next steps are in the committee's consideration of the potential for an act.
Yeah, so what an exciting time to be a human rights advocate in Queensland. You know, we've got this public discussion going on about how human rights are protected in Queensland and how we can strengthen and improve those systems. And I think it's exciting that all of us currently have a real opportunity to talk to the government about their opinions about that. And currently that's through making submissions to Queensland's Human Rights Inquiry, which you mentioned at the beginning, Lindsay. So the campaign's currently encouraging everyone to give their views to the Human Rights Inquiry. Those submissions are due by the 18th of this month. And then the committee will consider those submissions, hold some public hearings, make some recommendations by the 30th of June.
Good.
So I should say as well that our website, which I think is on the bottom of the screen, contains some great resources to help people to make submissions. So we have a discussion paper that really goes through the characteristics and benefits of a Human Rights Act, and we also have some fact sheets that help to explain the benefits to specific discrete groups.
Good, thanks Amy, and certainly PeakCare will be putting in a submission, and so certainly our members and supporters are invited to contribute their views to the submission that we'll be formulating and submitting. So finally I'd like to thank all the panel members for their contribution today, and invite you to make sure you visit the website and get in touch with us if you would like to be a part of contributing to PeakCare's submission. Thank you very much.